Hello, and welcome to AWCI's webinar, AI and Automation at Construction Sites, Powerful Tools or New Source of Liability. I'm Anne-Marie Salvatelli, Director of Education and Member Services at AWCI. Before we start, a few housekeeping items. All attendees should be on mute during today's presentation. Should you have a question at any time during the broadcast, please submit it by clicking on the question icon at the top right corner of your screen, and we will address any questions at the end of today's presentation. We are joined by Richard Whiteley and Phillip Sampson. Richard Whiteley chairs the Bracewell law firm's construction litigation practice group and guides clients on drafting effective construction contracts and managing litigation on issues such as force majeure, indemnity, defect claims, and product liability. Phillip Sampson Jr. is a partner in the Houston office of Bracewell. He represents clients in a diverse range of complex business litigation and arbitration matters involving the energy, construction, insurance, manufacturing, steel, oil field services, chemical, petrochemical, software, financial services, consumer products, and real estate sectors. So with all of that and their many hats, I welcome Richard and Phillip. Good afternoon, gentlemen.
Thanks, Anne-Marie, and good afternoon, everyone, and thank you for joining us. As Anne-Marie said, I'm Richard Whiteley, and I'm here with my partner, Phillip Sampson. We're both commercial litigators that specialize in construction litigation, and we represent clients across a wide range of complex construction, energy, and manufacturing disputes. Today, we're going to talk about a topic that is moving faster than most contracts, insurance policies, and even most job site safety protocols can keep up with. We're going to talk about artificial intelligence and automation on construction projects. And our goal for the next 45 minutes is simple. We want to help you spot where these tools create value and where they create new liability exposure and what you can practically do about it before a loss happens, not after a loss happens.
And this area is also, it's interesting because this is all happening real time. And so Richard and I, we've been practicing construction litigation for a long time. We've tried a lot of cases together involving construction litigation. We're pretty well aware of the liability issues, trying to avoid it on the front end, and then what happens if there is liability, and then the evidentiary issues once you get to trial. But with what has happened with automation and AI, things have changed and have expanded and become more complex. So we're kind of learning and working our way through this at the same time that y'all are. So it's a pretty interesting subject.
Here's our roadmap. So we'll start with where AI and automated tools are actually being used on project sites today. I'm sure many of you have already seen that happening. It's more common than many people realize. Then we'll walk through three categories of liability this technology creates, and we'll present a hypothetical to kind of make that more concrete for you. And from there, we'll move into the practical part of the session, how to safeguard against this risk through your contracts and through your insurance coverage and through some practical checklists that we'll provide to you that you can put to use. And we'll close with our key takeaways, and we'll leave you some time for your questions. And as you've seen already, Phillip and I will be trading off throughout the presentation, so you'll hear from both of us.
So why does AI liability matter for this particular audience? First, while it is emerging, it is already on project sites. Equipment is used, bricklaying, rebar tying, machines, inspections, drone monitoring, scheduling, all kinds of use that's in existence right now. However, there aren't any OSHA standards for robotics. So disputes are going to fall back on workplace safety protocols, very importantly, contract provisions, and then your standard products liability and negligence laws. Specialty contractors and field crews may have direct exposure here, They may be liable. They may face exposure when they misuse, override, or improperly operate these types of automated systems that may cause injury or property damage or delay on a project site.
So let's start with where this technology actually stands on job sites today. And, autonomous and semi-autonomous equipment has moved well past the pilot stage. I think we're seeing more semi-autonomous equipment at this point, but that's going to bleed over. And in the future, you're going to have more fully autonomous equipment. We see it in progress tracking, and that's more kind of a computerized AI function and scheduling. But once you get out into the field, you see drones out there, and they're monitoring and inspecting projects. It's increasingly appearing in physical equipment like excavators and bulldozers and trucks. You see Waymos out on the street now, and you see them with these trucks and bulldozers on construction sites too. You see a lot of loaders and equipment that does tedious type of work like bricklaying and especially rebar tying machines. The you know the appeal for this equipment is obvious. As the slide shows, a 2022 study found that construction robotics can reduce competitive or repetitive labor by up to about 90%, and those are significant numbers. And it also reduces worker exposure to hazardous conditions by 70%. And that explains why the adoption of this technology is accelerating rather than slowing down. But, and this is kind of the reality of the theme of the whole presentation, the pace of the adoption of this technology is kind of running at a speed ahead of the pace at which contracts and insurance and regulators have addressed it. And so there's some pitfalls out there to deal with that hopefully we can help you with today. So this is the structural problem underneath everything that we'll discuss today. There's no OSHA standard specifics to robotics, which Phillip mentioned, and so disputes over automatic equipment will not get resolved under the processes and the tools that we've always had: safety protocols, contract provisions, negligence standards, and products liability law. That's what we have to rely on until regulations catch up. And none of these processes were built with this technology in mind. And most statutes, codes, contracts, and job site protocols were written, exclusively for human decision makers. And they don't contemplate a system that can malfunction, misclassify a hazard, produce an error that nobody catches. And so the fast speed at which we're adopting this technology is sitting on top of a legal framework that really wasn't designed for it. And that's the mismatch where the liability hides here.
So with that gap in mind, let's talk about where the liability can actually show up. So when AI or robotics are involved in construction losses, the exposure and liability generally falls into three buckets. First, you have potentially resulting personal injury or property damage. Secondly, you can have construction defects, which are issues in and of themselves, but may also lead to the third bucket, which are delay or potentially disruption type damages. And you should keep these three types of damages in mind as we go through a hypothetical a little later, because you will see how these three distinct types of liability are going to all occur at the same time because of issues with an AI related loss. Now, here's what can make AI related claims somewhat different and unique from a traditional construction dispute. First, is the number of parties that may be involved. Liability can span the owner, prime contractor, subs, equipment manufacturers, technology vendors, as well as software entities. That's not completely unique in the AI context, but it's kind of exacerbated when robotics and AI is involved. Secondly, uh, standard AIA contract forms don't ordinarily include provisions that specifically address AI or autonomous equipment. So the contracts that you're generally going to be operating under simply might not address the particular AI related situation that you find yourself in. And then thirdly, manufacturers and vendors, software companies, they're sophisticated and they are very good at limiting liability for these types of issues. Caps, disclaimers, waivers are often in contracts that for a number of reasons go unnegotiated, and down the road if a loss occurs can really have consequences.
So I'm going to go into this hypothetical that Philip just talked about, and it involves an autonomous hauler, and that hauler is in a mixed traffic zone on a construction site, and it misinterprets a worker's path due to a sensor glitch. It fails to stop, and it strikes and it injures the worker. And so the next thing that happens when you have an accident like that is you end up with potential litigation. And so the contractor gets sued for personal injury. OSHA comes out, they issue citations, and the owner is likely going to be sued as well. Then the manufacturer who gets pulled into this dispute, the manufacturer claims the contractor failed to segregate pedestrian and vehicle traffic or update the AI's site plan. And as all contractors do, they're going to assert an indemnity claim at this point, and the manufacturer is going to point to its own disclaimers and its liability caps, leaving the party that built the faulty system largely protected and insulated. And that's something we'll talk about later, as these vendor contracts, which oftentimes are not given the attention that they should be. We seem to focus on, the owner contractor AIA contract and the subcontractor contracts, but those manufacturing vendor contracts are important. So the next thing that happens is delays occur on the project because you've got to repair the hauler, and then you've got other equipment that may have the same type of technology in it, and you've got to ground that equipment until it's checked and inspected. And that investigation and those inspections delay the project. It triggers, change orders, and there could be insurance coverage at issue, and so that's a different track that's going on, and those insurers may deny coverage. And so what you have is that a single sensor malfunction, worst case scenario, it turns into a full-blown litigation that delays the project and costs all the parties money. The technology failure is the easy part to explain, but untangling this web of risk and legal liability, that's where it becomes complicated, and that's where it becomes expensive. So who actually ends up holding the bag? Every construction dispute's different, but owners in general, general contractors typically are going to face negligence claims in this situation. They're going to be accused of, inadequate supervision, inadequate training, which we'll talk about later, or inadequate maintenance of the AI systems they've deployed. And because these systems are so new, some owners and contractors aren't as familiar as they should be with how to maintain these machines. Manufacturers and AI vendors are going to face, of course, products liability claims, negligence claims when the harm traces back to design flaws or inadequate warnings or faulty algorithms that they would have been responsible for coding. And specialty contractors and field crews, this is the group that I think we can focus on. They can be directly liable where they misuse, where they override or improperly operate the automated systems that cause the injury or property damage. When you've got a piece of equipment, or a machine, whether it's been around for a long time or it's one of these new automated machines, sometimes the workers on the construction site, they do things a little differently and they don't necessarily follow all of the safety protocols, and that's a recipe for disaster. This isn't an either or situation. And in the hypothetical, several of these categories, were in place simultaneously. And any of you that are, experienced with construction litigation, that's typical. It's not an unusual situation.
And really you have multiple parties, each with their own exposure levels, each with different types of claims that may apply to them. And in that setting, you're really looking at a particularly complex dispute.
And so here, this next slide, not to take too much time, but it's a quote here that I think it's really the thesis of everything we've covered so far. And this is a quote from an article that Phillip and I wrote that was published in AWCI. And it's, liability will not attach simply because AI was present on the job, but it attaches because one or more of the parties failed to supervise, to document, or minimize the risk, or train their employees in a way that matched the technology's role on the project. In other words, the technology itself can't be blamed for the problem. It's not the legal problem. It's how you manage it and how you run it and how you supervise it.
So how do you actually protect yourself? Let's start by talking through the contractual side of things. This technology, it is new, but the best strategy for managing it isn't new at all. And it's simply making sure that the risk scenarios that you're going to encounter are addressed head on in your contracts that govern the conduct at the job site. First, on most projects, the most important claims may be contractual rather than tort-based. So the parties are going to look to the prime contract, subcontracts, consulting agreements, very important with AI, vendor terms to determine risk, who promised what, indemnity. It's all contractual. So that's incredibly important. The problem is that the common clauses on means and methods, design, safety, correction of the work, those types of common clauses, they're not created with AI in mind. So what should you be asking for in your contracts that involve projects where AI and automation is involved? First, disclosure. The parties should be required to disclose, when AI is being used, who's using it, what the systems are. You need to know what's out there. Secondly, the definitions in the contracts. You're going to want to define AA systems and automated equipment broadly enough to capture software, robotics, drones, all these types of ways in which AI and robotics can be used on the job site, because vendors they like to argue that their particular tool, whatever it may be, doesn't fit within a definition. The definition is too narrow. So third, you're going to want to specify who selected the technology, who is authorized to operate it, who's responsible for it, the training required, and whether human review of the output is mandatory. The human output side here, human oversight is actually, we're going to come back to it because it's a very important way to provide protection that you can build, what you need to build into your contracts. So practically speaking, where do these types of contract provisions go? Where do they fit in? Well, they can live directly in the contract itself, either as a dedicated AI technology or automation section, or in an appendix or exhibit that's referenced in the standard contractual representations and warranties, disclaimers, or indemnity provisions. But owners shouldn't necessarily wait until they're negotiating a contract to raise the issues. They should address AI in the bid packages and the draft contracts that go along with those bid packages, so that those the owners deal with will know in advance what's going to be expected of them, disclosure requirements, so everyone's on the same page, and it's all out in the open.
So let's talk about here some of the specific provisions that we recommend you add or revise. So there's 4 on this slide and 4 on the next slide. I know a lot of times construction projects are governed by AIA contracts, but while AIA includes AI, the contract does not. And I suppose when we start getting the 10-year revisions of the AIA contracts, they'll catch up. But at this point, you can add them into those contracts either in the other provisions section, or I think more preferably for new provisions, you reference them in that other provisions section, and then you add an addendum like you do for other things. Oftentimes, insurance is added as an addendum, and so there's different ways to kind of do this, but those are the ways that I'm seeing it done and the way that I'm doing it when I revise contracts. So one that Phillip referred to is add definitions of AI technology and or automated equipment, so that the rest of these contractual provisions that we add, we know what they apply to. So 2, you want to have disclosures identifying the tools and the systems that are at the project, and you want to identify who those tools and equipment and machines belong to. It's very important to not only have that definition, but also the actual components at the site. And it's important to, keep an eye out, because you're not going to know potentially every machine that's going to be used at the stage where you're negotiating the contract or drafting it. And so it's important for, construction managers and owners and others to recognize when new equipment shows up that's not referenced, and to add that. 3, you want to include human in the loop clauses. AI, it's provides the output, and it supplements the work, but it doesn't replace professional judgment. It doesn't, replace what we do, and it's important to have contractual provisions that state that. And then 4th, you want to modify safety clauses to require procedures for operating, monitoring, and overriding AI equipment. And that's so, that you can prove after there's a potential incident that a human had the ability and potentially the authority to stop the system. And it's also important to, have those safety clauses for training purposes, and so that everyone knows what they're responsible for on the front end. So, second slide here. I want to flag this one because it gets not a lot of attention. But 5, address up front, which parties are responsible. I've mentioned that, but this kind of takes it to a different, more specific level. Like we talked about in our hypothetical, there's different things that can go wrong, and so you want to make sure that the parties that are listed that are responsible for data errors, the ones that provide the data, the ones that provide the code, the ones that provide the software, who's using it, who provides the design. So you also want to require data retention and clauses to preserve logs, alerts, updates, incident records. We'll talk about that later as well, but a lot of what happens with these machines is going to be recorded. And you've just got to make sure that all of that data is kept and it's not overwritten, because it becomes very important, and it provides, if it is overwritten and there is an incident, then you get into legal issues like spoliation. So 7, you want to include carve outs from damage caps that reflect project level exposure. And this gets back to those vendor contracts that I talked about, which is they're going to try to, limit and cap the damages to the software subscription fee and the price of the contract. So you want to address that and make sure that you're not limited in that regard. And then, of course, you want to make sure the indemnity clauses that you should already have, address AI issues, and they have provisions for bodily injury, property damage, rework, related to AI equipment and automated equipment, and even more importantly, some indemnity provisions already have IP issues, but obviously with the level of technology we're dealing with, there can be infringement claims for the technology, and you want to have a clear indemnity protection in those indemnities for any kind of intellectual property claims. So we talked a lot about the vendor contracts, and this is a slide that's pretty specific to it. Equipment manufacturers and vendors are really sophisticated. They're aware of what the counterparties do, who buys their product, what kind of forms they use, and they know what forms are very good at limiting their liability. And these, as I mentioned, these contracts are often left unnegotiated at the job site level. And one of the reasons for that is you're focused on the project, obviously, and you're focusing on the bid package, you're focusing on those particular contracts that govern the general contractor and the subcontractors and others. Oftentimes, these vendor contracts they're longstanding. They're master service agreements because you're continually purchasing these products. And so you may not be executing and reviewing a new contract for every project. You may be just acquiring what the vendor has to offer through a contract that's been in place for several years. So you got to go back and review those. And, if you don't carefully review them, you may discover after a loss that those boilerplate disclaimers and consequential damage limitations and those liability caps, and those warranties that are disclaimed, that it's going to affect your risk, and it's going to affect what damages you have to pay and what you can't pass on to someone else that may actually be the cause of the problem.
So even with good contracts, AI-related disputes can add evidentiary hurdles on top of usual fights over liability when you get to the courthouse. And this is particularly important to practitioners like me and Richard, who we not only advise, on site and with respect to projects, but we handle disputes that come out of them, and we try those lawsuits, and those trials are based on evidence. You can tell a great story, but it has to be backed up by evidence, and the preservation of evidence is difficult, made more difficult in certain AI settings. The problem is that, to begin with, reconstruction of what happened is harder because AI, related disputes usually, in addition to the ordinary fight over fault, they're complex because there's interaction among humans, machines, and changing site conditions. Vendors also often control the evidence. The most useful evidence is in vendor-controlled logs, data, update histories, cloud-hosted data that may or may not be preserved automatically after an event. And because of these issues, your counsel should expect aggressive discovery fights over access to all kinds of data, including training assumptions, histories, alert histories, software updates, override records. And if you don't preserve the information right away, you can lose some of the best evidence of what the system saw and was doing and recommending in connection with the loss. And so both externally, in terms of sending out data preservation notices to other parties in connection with a loss to make sure that this information isn't lost to the best of your possibilities, but then also internally, sending out document and evidence preservation notices to make sure you don't lose data and evidence is very important, particularly when you're dealing with electronic information and AI. All right, so let's shift to insurance because a good contract only helps if there's coverage behind it. So insurance, it can often soften the impact of an AI-related loss, but only if there's coverage that actually applies to the loss. And here's the problem. There aren't any policies, any kind of form policies that were built for AI. Your existing commercial liability policies, workers' comp, builders' risk, cyber technology policies, um, they may they may discuss, they may apply in some ways to AI, but none of them were specifically drafted with AI. None of the typical contracts were specifically drafted with AI in mind. And that creates an issue when we have particularly what we think of as a hybrid loss, where bodily injury is caused by faulty software or property damage results from uh, errors in automation. Coverage disputes are a real risk here because the loss involves both physical and digital aspects.
So questions for your broker, and that's the title here of this, but coverage counsel is also kind of important here. I know, um, most of our clients, they have brokers that they really trust, and that's the first place they go to, and brokers are extremely knowledgeable about the specifics of the client's policies. And so that's the first place that you go. But again, if you have coverage counsel, Phillip and I are construction lawyers, and we know quite a bit about insurance, but not everything. And we have coverage counsel here that we talk to all the time in the context of disputes. So here's the questions you should be asking in the context of AI and automation: is do software or cyber related exclusions create gaps in your coverage? And Phillip just mentioned that there's not a lot of insurance out there that covers incidents caused by AI, but there are exclusions. So, the insurance company is out ahead of on the exclusions as usual. So secondly, does additional insured status actually lock in coverage under the AI vendor's own policies? And that's an important question. I know that a lot of clients push hard for additional insured status, not knowing that it really, in many cases, doesn't mean much. So you've got to really ask those questions. Thirdly, does professional liability coverage extend to AI assisted design or coordination work? This can bleed over to your designer, your architect, and there's been BIM systems in play for a long time now, and but that's not AI. But you really want to make sure that while there's certain technology issues that are addressed, that includes AI, which is a little bit of a different animal. And then fourth, do your policies require immediate preservation of digital evidence after an incident? We've talked about that and how important it is to litigation and how important it is to not having negative effects and being sanctioned by a court for inadvertently deleting evidence, but also how it helps your case if the evidence is good for you, so you get to see what's going on. But then the third level of that is, if your policy requires you to preserve digital evidence and you don't, then what's the insurer going to do? They're going to deny your claim immediately. So vendor E&O matters as much as indemnity. Here's a point that's really important. Requiring your technology vendors to carry meaningful amounts of errors and omissions coverage, just like any kind of coverage, is just as important as negotiating an indemnity clause, because if you don't have that insurance backing up that indemnity, oftentimes there may not be a lot of assets behind that clause, and practically your vendor may be very thinly capitalized and the only asset is their software, and you're left holding the bag or holding a piece of paper that doesn't get you anything because your E&O the E&O policy is not any good. So make sure that the coverage exists to back up the promise. And when you go through all those other types of insurance when you're negotiating construction contracts, this should be part of it and added to the list. And oftentimes it's not. We focus on builder's risk and CGI policies and what the limits are, and we should be doing that with these policies as well. So let's bring this all together into some practical approaches that all of us can start acting on. So this is a 6-item checklist that I found is very helpful. It's very practical. So first, you should audit your technology before it gets deployed. We do that with trucks, and we do that with other equipment. We test it, and the same thing should be true for automated equipment. Know what's on your site and know who brought it to your site and who bears responsibility to it. We've talked about this, but update your contracts for that, and do that now, especially if you've got those long-standing MSA contracts or supply agreements with your vendors that you don't, execute every time you have a construction project. Go back to those and amend them and address AI issues so that you don't have to do that after a loss. Third, in those contracts, demand an indemnification that has teeth, and push back on liability caps, which are almost always very insufficient for construction exposure. Fourth, you've got to document the human oversight, since regulators and counsel will ask you either on the front end when the investigation's taking place or on the back end at a deposition, whether a human actually reviewed the AI's output before action was taken, whether training was provided to the humans that are supervising the AI, whether it was maintained. 5, review your insurance program like we've talked about. And 6, train your people, since liability increases when workers misuse or over rely on automated systems or decide to use shortcuts or use their own processes that may be outside the scope of what that automated equipment is equipped to handle.
So you also need a process to follow if and when something does go wrong. Our recommendation first, you want to document whatever you can as promptly as possible. Clearly document the loss, any potential causes. You want to do this as soon as you can while memories and data are still fresh. Secondly, investigate. Have a process in place to investigate the loss, interview relevant people, and preserve all evidence related to the loss, like we talked about earlier. Here is an investigation framework that we often utilize. First, you're going to look to see which party selected and configured the technology for the part of the project that had an issue. We look to see which party controlled the conditions of using the technology, training, supervision, exclusion zones, override authority that are connected with it. We look to see what the contracts say, of course, about means and methods, safety, design responsibility, reliance, identification, very tricky and very important, and evidence preservation. We look to see whether the failure stemmed from defective technology, bad input, it was a human error, unsafe fail conditions, or some combination of these things. And then, finally, we take a look at the policies. Which insurance policies are most likely to provide coverage once you have figured out what the basic facts are for the loss. And while this framework won't necessarily eliminate all gray areas, it will help identify where liability and exposure most likely rests.
Okay, let's wrap up with key takeaways. And a lot of this is kind of restating some of what we told you already. So I won't spend a whole lot of time on these slides, but AI intensifies the need for risk analysis. It doesn't replace your traditional risk analysis process that you have. It just it intensifies the need for it. Like we talked about OSHA, the current state of construction technology, and the structure of standard AIA and other contracts. They're trying to catch up, and they aren't sufficient to identify where liability falls. So it's up to you to rework some of those contracts, and you need more specific rules, more specific processes, and more specific contracts that address AI issues rather than relying on previous frameworks. So make the risk more visible before the loss. Make it more visible before the loss happens. Get out ahead of it. Audit what AI is being used on your project. Revise your contracts. Allocate the risk appropriately in those contracts. Demand better from your vendors instead of accepting what you've accepted in the past. Implement policies to preserve evidence. Make clear that human responsibility and accountability are still imperative. Demand accountability from your workers and from your humans on the construction site, but train them and prepare them as well. As our article puts it, firms that deploy AI can gain real advantages in safety, speed, and cost. And like we mentioned at the very beginning, we're talking about liability and injury caused by AI. But if you use AI properly on the job sites, it can actually reduce the exposure your workers have to being injured. So if it's done right, it can be a positive gain. Okay, so I wanted to open up for questions. Thank you for your time today. And I see that there's one question already. From a litigation and risk management perspective, what should our company be doing now to document and preserve the data generated by AI and automated systems, particularly if that data could later become evidence in a dispute? So with paper documents, it's easy. You just keep those paper documents. Where we see clients run into issues is where there's electronic documents and electronic evidence that is subject to certain overriding procedures, just like as simple as your Outlook, your Outlook inbox. Once you have an incident that occurs, you want to turn off any automatic deleting programs, and you want to freeze all of that information. Our inboxes, they delete information in emails after about 6 months. And so it's important to folder all the emails. And specifically with AI, the problem with AI is that oftentimes the vendor and the manufacturer is going to have control of how, what the settings are on the information as to how it's stored, how long it's stored, and when it's overwritten. So on the front end, you want to have that information at your fingertips. You want to ask your vendors about it. You want to make sure that the settings on it are reasonable and appropriate. You want to make sure that you have employees at your company that understand it, how to change it, how to preserve it, how to save it. You want to make sure you continue your relationship with that vendor and have a client representative that you can reach out at any time, a technical assistance representative that you can reach out to at any time, that if there's an incident, all that information, all those photos, all those videos, all of that stuff is preserved.
Yeah, really, anywhere that you have electronically stored or generated data, just like with emails, you, number one, want to make sure you know right now before a loss occurs, and you need to retain the data. You need to make sure you know what are the settings now, what's going to happen to this data over time, and how do I, if I want to retain it perpetually, how do I make that happen? By talking to your IT person or the vendor, if you don't have an IT person, to make sure you know, how do I put these systems in a mode so that we retain the data? And then secondly, as soon as a loss occurs, you make sure that you have a procedure in place at your organization to implement whatever this method is that you have already learned about to retain the electronic data.
And don't forget, like we talked about, your insurance may require you to preserve that data too, which may help you in your conversations with your vendors. Sometimes, most vendors, if they're good vendors, they're going to be open to this. They want to make sure their customers happy and they want to sell products in the future. Occasionally, you run across difficulties and reticence to address these kind of issues, and you can let that vendor know that, look, this is not a negotiation; it's a requirement because our insurance requires it to provide coverage, and so it needs to be addressed. So, next question. How do you see responsibility and liability being determined when an AI-driven decision or automated system contributes to a construction defect, accident, or delay? So I think the first part of this is the responsibility. And that's what you're going to want to map out at first. Who's the manufacturer of the automated equipment? What does that vendor contract say? If you've revised your contracts, like we've suggested, you're going to have an inventory of everything that's on the site and who's responsible for it. And that's the map that you follow. So liability is the second part of it. Insurance is an important backstop to that, to make sure that you have insurance that covers AI-driven losses. But again, it's all in the contracts. That's where the liability is going to flow. And, you've got to make sure that you protect yourself and you allocate risk appropriately with your partners on the job site. Again, that sleeper issue is so important here. That's where, if something goes wrong with some AI equipment that can't be prevented by human oversight, which the contractor and the owner are going to be responsible for, it's often going to be, some kind of defect in a sensor, or maybe a design defect in the product, or maybe, the programs that run these different machines, there's a defect in the way those were coded. And that should all flow back to the vendor or the manufacturer. So, Phillip?
Yeah, I mean, these are all case by case, very fact specifically driven, issues. But in general, the way I think of it is, how is this going to be determined? It starts with an investigation and essentially the reconstruction of what happened, what failed, who was involved, why did it fail. It may turn out to be an issue with the technology itself, which would point to certain parties. It may turn out to be an issue with the person operating the technology, which would point to other parties. And like Richard said, like we've talked about, the contracts at issue are going to be the overarching, the umbrella underneath which are all of these issues that will be determined based on what the investigation reveals, and then what the contracts say about responsibility and liability.
All right. Well, gentlemen, thank you. It seems those were the questions that came in from today's participants. So on behalf of AWCI, I would like to thank Richard and Phillip and all of our attendees for joining us on this webinar. And we wish everyone to stay well, and we will see you next time. Thank you.
Thank you.
Thanks, Anne Marie. Thanks to everyone for attending.